Thank you to everyone for joining us today. And thank you very much, Hal, for joining us as well. I'm really excited about today's what I'm calling a virtual lunch and learn. My name is Lindsay. I'm the co-founder and CEO of Super. We're a technology platform building software tools to help property managers and building boards streamline operations, governance, improve communications, and elevate the resident experience. We call it the operating system for buildings. But why did we build Super? Well, I've been on the board of 3 different condos over the last decade. And so for many of our board members in attendance today, I feel you. The board experience can really throw you into the deep end. It's just an added challenge to find helpful resources to navigate the work as well. And being on a board is important. It means that you're signing up for responsibility for the financial health, safety, and good governance of your building, and for your investment and whether your other owners and shareholders will grow that investment as well. You're making tough decisions. You're having conflicts potentially with your neighbors who you see and share space with. And on top of all of that, the regulatory environment in New York means that more boards and managers have to understand compliance as well. And all of this while you're a volunteer. It's insane. So, like I said, I feel you. Super software platform aims to help boards collaborate and communicate more effectively with each other so that you can make decisions with the fellow board, with residents, and with your management teams by bringing the tools for everything you need for financial oversight, easy meeting planners and minute saving, as well as automatic storage of your building history, files, and data. But having a shared understanding of these responsibilities and what good governance looks like is really the foundation for a strong board. So today we're really fortunate to have Hal Coopersmith, an experienced real estate attorney and partner at the law firm Coopersmith Coopersmith, join us to share some foundational educational information and make time to answer your questions. Before I turn it over to Hal, if you haven't used a Zoom webinar before, there is a little Q&A button at the bottom of the screen, and you can throw your questions in there. Feel free to write those as we go. We'll make sure to leave ample time at the end to answer these, but you can kind of throw them in there as you start having questions so that we can get to them. So with that being said, I'm going to turn it over to Hal. He's got a quick presentation with some tips and information, and then we'll turn it over for Q&A.
Let me share my screen. Everyone see that? Well, thank you, Lindsay, for that introduction and the opportunity to be here. And I want to thank everyone for joining, not just for your time today, but I know working with a lot of co-op and condo boards and serving as a board member myself, that being a board member is often a thankless job. To Lindsay's point, a lot of your neighbors who you may be in conflict with don't realize a lot of the work and effort that you put in towards governing the board and a lot of the decisions that you have to make. So as a thankless job, I wanted to offer my thank you for your service to your building and for your time here today. And to Lindsay's point, we are going to be talking about building a better board. And there's a lot of directions that we could have done in terms of co-op and condo governance. We could probably do a week of seminars, but instead of that, we're going to keep it relatively short, focus on a lot of the foundation for what it means to be a board member, some things that you can think about. So rather than doing a whole week's worth of content, just start with a lot of the foundational building blocks. And at the end of the presentation, there'll be an opportunity for Q&A. I'm also happy you'll see to do a private strategy session, at the end. All you need to do is sign up. So with that, let's talk about what it means to build a better board. First, let's talk about your responsibilities to be a board member of your co-op and condo. The best place to start is what the law actually is. And this comes out of the business corporation law, which governs what your responsibilities are. So at the top, it says, you're responsible to perform your duties in good faith and with a degree of care which an ordinarily prudent person in a like position would use under similar circumstances. You'll see that this is throughout the presentation, this is essentially the foundation of what your responsibilities are. And a lot of reason for where there can be conflict or where you might not properly discharge your duties, but you have to perform your duties in good faith, as a reasonably prudent person would. Sometimes you'll find that there are absentee directors, and I'm not going to say, that they're not fulfilling their obligations, but again, essentially your baseline is to discharge your responsibilities in good faith. Certainly by investing your time today and learning more about co-op and condo board governance, you're making that investment. And in terms of what the responsibilities actually are, you're not responsible for being an expert. You're certainly an expert in terms of your building, what it looks like, how your neighbors act, and perform, and any complaints that you get, and what it looks like when you walk into the lobby, or anything else in your building. But the second part of the law is that you're entitled to rely on information, opinions, reports, or statements prepared by committees of the board, officers or employees of the corporation, counsel, public accountants, and other matters which are in such person's professional or expert competence. So again, you're not responsible for knowing all the ins and outs of your financial statement. That's the responsibility of your accountant. You're not responsible for knowing all the updates to the law. That can be part of your property manager or your counsel. But you're entitled to rely on the opinions of these experts, which the board hires. And in terms of who these experts are, it's kind of a very good segue in terms of the discharge of duties. Just for one small example, and we can go through other ones, but an easy one to go through is a property manager. What's the difference between a property manager and what the board is actually responsible for? So an easy way to segment this out is that the property manager is responsible for the day-to-day management of your building. That includes cleaning, for example. As a board member, you're not necessarily responsible for scrubbing the windows, but during COVID, for example, how often was the building being cleaned? Certainly, if you lived in a building with a gym facility, creating a policy for cleaning was that of the board, but executing on that was the responsibility of the property manager. Same with staff in terms of if you live in a building where there's staff, property manager is responsible for coordinating vacation days, making sure that that staff is being timely paid, that bills are being timely paid. Those sorts of items is the responsibility of the property manager, wouldn't necessarily fall onto you. If some of these things are falling onto you, maybe a time to reevaluate who your property manager is. Same with emergency maintenance. If there's an emergency that pops up, it's not incumbent just by being a volunteer on your board that you're responsible for calling a plumber in the middle of the night to fix a leak or something else like that. And similarly, if there are long-term repairs or capital improvements, soliciting the bids is the responsibility of the property manager, but determining who will perform the work is the responsibility of the board. So in terms of the board versus a property manager is more day-to-day. Board you can think of as more in terms of long-term strategy. So what are these policies that you're setting in place for subletting if you're in a co-op, leasing, cleaning, vacation, all those sorts of items. Selection and evaluation of the professionals. So in terms of what your financial statements look like, whether or not you might need a new CPA and or property manager or counsel, in terms of whether or not you think that these or property management software, whether or not you think that what you're using right now or the services that you have are appropriate for your building. Long-term budgeting, certainly something to think about that falls in terms of the board's responsibility. That's something that you would work with in conjunction with your property manager, but that's something to think about in terms of the board's responsibility. So capital projects like a boiler or roof repair or water tower, those items are something for the board to think about and plan ahead on. Similarly, fees for subletting or transfers, like a move-in, move-out deposit, move-in, move-out fee, sublet fee, that's an alternate source of revenue for a board, is the responsibility of the board and not something that you would rely on your property manager to implement. Property manager works with more buildings than you work with, so it might be helpful to rely on their advice to make sure that they're in line with market, but it's ultimately the board's responsibilities for fees. And then finally, ensuring that whatever strategy you choose is implemented. And so that's ultimately what you are thinking about as a board and discharging your duties. So we talked about how co-op and condo boards are governed by the New York Business Corporation Law. One of the main aspects behind the Business Corporation Law and the interpretation of it is something called the Business Judgment Rule. And we're going to unpack that a little bit. But in terms of being a board member, you're responsible for using appropriate business judgment for how the board and how your building will operate. The key to this is a very famous case, Lewandowski versus 1 Fifth Avenue, where this was first implemented or as case law. And in this case, Lewandowski wanted to perform alterations to his apartment, and he wanted to move a steam riser, and ultimately did. The board didn't formally approve the movement of the steam riser, and even though there wasn't damage to the steam system, the court ultimately sided as there wasn't any damage to the steam system as a result of Lewandowski's alteration. The court ultimately sided with the board, saying, despite the fact that there was no damage, no harm, no foul, the board, in its reasonable business judgment, was right to say, you're not allowed to make alterations to the steam system without our consent. And that's how the business judgment rule first came to be. So as long as you're using appropriate business judgment as a board, well thought out reasoned judgment, you're allowed to make decisions on behalf of your building. Even though in this case, there wasn't any harm for the steam riser. The same thing, this was further clarified and ratified in another famous case, 40 West 67th Street versus Pullman. And this is about good faith, reasoned decisions. And in this case, the board decided to terminate the lease of one of its shareholders based off of behavior that was not appropriate for the board or the building. It was really harassing behavior. We're not going to go too deep into details, but essentially a board's decision to terminate a lease really has such a high threshold, and the behavior really has to justify it. And in this case, the court found that it deferred to good faith decisions by the board in terms of what this harassing behavior was. So again, using good faith judgment is part of the business judgment rule. An important case that came up is that the business judgment rule does not shield co-ops from liability for breaches of contract. So sometimes it may make sense in terms of business in your own business to breach a contract, to terminate a contract. But just because it may make sense doesn't necessarily shield the co-op from liability, or the board of directors from liability for breaching the contract in terms of the decision that the board makes. So a practice point that we have is boards should definitely offer, it's called D&O coverage or insurance coverage for directors and officers. So that if there is a claim for a breach of fiduciary duty for the board not exercising good faith judgment, that it's covered under insurance. And you, like any insurance, you hope to never use it, and you want to make good faith decisions. But it can, it's certainly extremely important when it's needed, and it's come into play many times in terms of our practice and seeing how people can sue for a breach of fiduciary duty, and then you need that D&O coverage. So it's certainly important to know that you have it and know that you have market coverage for within the trusted insurance carrier. That's a critical thing to take away from today's presentation. So what does good governance look like? Boards certainly have to comply with the law. One of the main requirements is to have an annual shareholders meeting and elect directors. That's critically important. Sometimes you may not find that in small co-ops and condos, but absolutely it's something that you want to have. During COVID, the law changed to allow for electronic board meetings electronic shareholder meetings. So Zooms like this, as long as people are able to ask questions to the board members, and that certainly made life a lot easier. And shareholders are also entitled to examine and review shareholder meeting minutes and the financial statements. What are some things that a board does effectively? Certainly prepares annual budgets and timely financial statements. So knowing what's in the budget that you are appropriately budgeting in the future. Work with a CPA to understand what's in your budget, what some of those obligations are. And like I said, plan for long-term capital projects. Certainly, if you aren't aware already, a major change in the law, which is going to take effect starting next year, where there'll be small fines, and then starting 2030, larger fines, is Local Law 97. Local Law 97 is about CO2 emissions, so fossil fuel emissions. Doesn't necessarily correlate to what your energy grade on your building is, but understand what your Local Law 97 obligations are, what your fines will be, and what's necessary for a capital improvement. If you live in a brick building, certainly Local Law 11, understanding where you are in your cycle and when you're going to need to do facade work and facade maintenance. Third point on here, which is really important, is keeping good records for board members and transitioning in terms of leadership. When I was on my co-op board, our property manager was responsible for all of our records. And anytime we wanted something, we needed to ask our property manager for it. And sometimes they would send it timely or not at all, and we need to follow up. But there wasn't, certainly a repository for all these items, which I think is the problem that Lindsay saw as well. And if you're constantly trying to look up documents using your energy for finding what are the governing documents of your building, what are your existing policies, what are your existing fees, what your budgets have been, where your financial statements are, that they're all in an email, and you're constantly just trying to tread water, you're not necessarily going to be an effective board. And particularly as a volunteer, where your time is already stressed with professional, personal obligations, using that time more effectively to think about more of the longer term trends is really important. And I certainly can't emphasize that enough. And then finally, as a board member, you want to stay up to date on changes in the law, what are changes in the market conditions and management trends. So things that as a board you may need to know about. Recently, a change in the garbage laws. So is your property manager keeping up with that, for example? A major problem that we can find for boards is conflict of interest, and knowing what a conflict of interest is, how to avoid it, can really help for a more effective board governance. And this can happen a lot because if you're in real estate, for example, you may have a natural inclination towards being on your board, not because you necessarily want to promote yourself or your own business, but that's just where your own interest lies. And coming up with a conflict of interest policy ahead of time, or knowing what that is, will certainly lead to fewer problems and a more effective board. So a conflict of interest, just by way of background, isn't necessarily dissent among board members or a conflict, but it's when a party who is interested in the transaction is a member of the board. And so an example of that could be a real estate broker who is on the board of directors, but has brokered a sale in the building. That is a conflict of interest. Shareholders are entitled to receive an annual report disclosing any contract or transaction where there was a interested party, even if the number is 0. So they can request that. And contracts or transactions where there is a present conflict of interest may be approved by a vote of the board without the vote of the interested director. And certainly disclosing what the material facts are to the board is very important. And then when there is a contract, for example, with, let's say, a service provider who's also on the board of the co-op, their company, for example, it's documenting what the alternatives would be and why the board elected to go with this service provider with a board of director. An easy way to avoid this is to not go with the service provider who is also a director. This one can really lead to a lot of trouble down the road. And we certainly advise against it wherever possible for a board to not retain the services of someone who, a service provider who's also on the board. Just wanted to touch on the difference between co-ops and condos real quick. You may be familiar with this, but it also affects the governance of your building as well in terms of co-op and condo governance. Condominium units are technically and legally real property where an owner has a deed and the relationship with the board of managers is a limited one. A co-op is where an owner owns shares in a corporation and gets a proprietary lease. And what's important with that is that a lot of landlord-tenant laws can accidentally meaning by accident of the New York State legislature, fall on co-ops, but don't apply to condos. In terms of the condo management, condo managers have a more limited relationship with unit owners, like a homeowners association. And in terms of admitting or denying new owners, their main source of authority is the issuance of a waiver of the right of first refusal. And it's certainly very rare where a condo elects to purchase a unit as a condominium. Usually they issue the waiver of the right of first refusal. That's why it's easier to rent out a condo as opposed to co-op. Co-op has certainly a more nuanced relationship, and right now a board can approve a shareholder or deny a shareholder for any reason or no reason at all. And like I said, there is certainly that landlord-tenant relationship as a result of the proprietary lease. So an example of that and how it can apply to co-ops accidentally is in 2019, New York State passed the Housing Stability and Tenant Protection Act, which was a sweeping reform of all residential leases. And they capped late fees, the legislature capped late fees at $50, regardless of how much rent a tenant was paying. This also applied to co-ops. So regardless of what the maintenance was, a co-op could charge only $50 as a late fee. And it certainly harmed co-ops in terms of how they were able to collect their late fees. It also harmed co-ops because they were not able to collect or hold money in escrow for approval. And it took about 18 months for the legislature to finally iron this out. But for that 18 months, co-ops were very much in limbo. And so, at least in terms of knowing what the law is and how the legislature applies that, it's important to understand that as part of a landlord-tenant relationship, co-ops certainly have it a lot harder than a condo. In terms of who can qualify as a director, pretty simply, you need to be at least 18 years of age, and the other qualifications are usually in your governing documents. So you need to be a shareholder or a unit owner or a spouse of a shareholder or unit owner. In terms of keeping up with the laws, just a brief summary of some of the things that we see kind of going on. E-bikes, understanding house rules or amending your proprietary lease about what your e-bike policy is, certainly a health and safety issue. Smoking, again, I put in parentheses because it used to be tobacco smoke. Now you'll see a lot more claims and nuisance about marijuana, and understanding what your building smoking policy is and whether or not that includes marijuana. Subletting and rental policies. I mentioned the Housing Stability and Tenant Protection Act of 2019. Understanding what those policies are. Certainly there are large applications for that in terms of subletting, condo or co-op unit, and new legislation. There's currently 3 bills pending in front of the New York City Council, which would drastically affect co-op operations in terms of approval, when approval would happen, what the rules are surrounding that, and just keeping up with a lot of the new legislation affecting co-ops and condos. That kind of concludes what I had to say. I wanted to end the presentation the same way that I started, with a thank you. Thank you for your time. Thank you for being a board member and taking on a very thankless job. My contact information is below. Please feel free to email me. And as I mentioned before, if you want to do a complimentary 30-minute strategy session with me, if we don't get to your question in Q&A or it's a little bit more specific, please sign up at coopersmith.law/super, enter in your information, and we'll get you scheduled for a strategy session.
Thank you so much for that, Hal. That was really insightful. I wish I had access to you when I was on my building boards. I was kind of operating in the dark there. Will we be able to share these slides with the attendees as well?
Yes.
Perfect. So we'll circulate all of that to anyone that's on. I do see we've got some audience questions that are coming up. I did want to kick off with a couple kind of broader questions and themes as well, if you don't mind. So my first thought is, I think one of the principles that Super has been kind of built off of from a software perspective is that transparency is necessary in order to build trust. It's one of the reasons that we make every communication through Super visible to board members. Do you have any recommendations for boards, aside from using us, for creating transparency and trust with their management teams and residents? I think that's an area of conflict that we certainly hear about quite a bit.
Yeah, I think it's really important, and it's I think something that's important for building operations, just at least in terms of what I touched on, is having a repository for documents, for the board is really important, because for good operations, at least knowing what the policies are and knowing what the governing documents are, using your time effectively as a board to not ask your property manager about what's going on with these documents, where are they, to have them in one central place. And from there, you're able to evaluate what those fees and policies are of the building, and having them in one central place. So you're able to change the relationship with your property manager, not in terms of requesting documents or other information, but to thinking about how to progress the building forward, and certainly communicate with all your shareholders and other unit owners. I think I've been on co-op board and I've not been on a co-op board. And I think that, at least in terms of what effective communication looks like, it's certainly extremely helpful to communicate with your shareholders. One of the things that was frustrating on my former co-op board is that we didn't have anything digital. So any correspondence had to be noticed by the elevator or mailed out. And that hampered our way to effectively communicate as a board. And there are certainly times where you don't want to communicate certain things that are happening in a board, the dialogue that you're having, certain board decisions with shareholders, so you don't get unnecessary feedback. But I think one of the most effective things to do is certainly have the governing documents in one place, and from there you can look to modify what those are.
Yeah, that's great. I mean, I have my own stories as well. One of the boards that I joined, my introduction was literally the previous board member came over with a binder with printed out emails, including the lawsuits with the sponsors, all of the historical. I was like, how am I supposed to make good decisions with this context? So I think that is a great tip on kind of preserving all of that. All right, we've got some questions. I'm going to read them out for you. First one, are shareholders permitted to attend all board meetings if they are not a member of the board?
Board meetings are open only to board members, and shareholder meetings are open to shareholders. There may be some instances where a shareholder is invited to a board meeting in terms of what a complaint is going on with the building, or some other situation that's shareholder specific. But just by virtue of being a shareholder, you're not entitled to attend all the board meetings. A shareholder is allowed to attend all shareholder meetings.
And those shareholder meetings have to happen at minimum annually. Is that correct?
Correct.
Yep.
Yeah.
Okay. Great. Another question around the D&O insurance. Who pays for it, and what happens if the premium increases because of a claim? That actually it's an interesting question, because it feels like a conflict of interest there as well.
So the D&O insurance is paid for by the corporation, and it's important, obviously, to have that and know what your D&O insurance is, and it's certainly a line item expense of the corporation. The reason for that is it can encourage directors to serve on the board, and it's a benefit for being a board member. Certainly, as a board member, you're a volunteer. Whether or not you want to volunteer for the responsibility that comes with being a board member without having insurance coverage would limit the number of people who were willing to serve on a board. Probably limit the number of people to probably zero, in my opinion. But it's important to have that D&O insurance. If the corporation, again, is responsible for increases as a result of claims on the D&O insurance. If there's a problem director that's causing the increases to the D&O insurance, that's certainly something that the board or the corporation should address. But it's ultimately the responsibility of the corporation.
Great. Thank you for that. We've got a couple questions about house rules. This one seems to be top of mind for some folks. So I think maybe just starting with the first piece of it, which is, how do you change house rules, and is there a process around that? And then we can go into some of the detailed questions.
It's a very good question. So in terms of the authority of a building, the strongest authority comes from the declaration. So declaration of a co-op or declaration of a condominium, which is filed publicly and recorded. And that's the strongest authority that requires usually the highest level of change. The next highest level after that would be the bylaws, proprietary bylaws or proprietary lease, which certainly requires a certain threshold of the unit owners or the shareholders, and that by reaching that threshold, that's an important. Those aren't changed very frequently. So the implementation of a flip tax, for example, requires an amendment of the bylaws or proprietary lease. And I bring that up because house rules are the weakest authority that there is, and that can be modified by a vote of the board of directors or board of managers. And as long as you have authority under your governing documents to amend the house rules for certain items, then a vote of the board can amend those house rules. But it's important to make sure that those house rules aren't amending the declaration or the bylaws. Otherwise, they'll be invalid. So you can't make a house rule to, for example, to change your flip tax because you don't have the authority to do that. That's looking at what the governing documents are. So as long as it's available by a house rule, then you can change that by a vote of the board.
So the bylaws would supersede the house rules, just to reconfirm what you said there.
Bylaws supersede the house rules,
Okay.
and declaration supersedes the bylaws.
Great. And then what about, we've got a specific question around co-op boards and the flexibility they have to amend those house rules to deal with issues. And I think specific to what you were saying there versus amending things like the proprietary lease or the bylaws, where should they be thinking about the level of granularity to apply that to?
Which was this Shaheen's question?
Yes.
Okay. Let me just I think certainly as I'm biased as an attorney, but I think that part of it is to ensure that your house rules don't violate the bylaws or the declaration, even though the board has full authority to change those house rules. That you certainly want to seek the advice of counsel before doing so, and understand what are things that you can amend versus not, and ensure that they're in compliance, because otherwise you don't want a house rule that's not in compliance with your other governing documents. I think that kind of goes aside from the legal aspect of it. From a practical standpoint, I think it goes towards building more trust with your fellow unit owners in your building, and more effective communication. You don't want to be seen as a board who is not exercising effective governance, shooting from the hip, for example, saying, oh my, I just saw this main issue or this issue in the news, and here we are amending our house rules. A lot of house rules aren't amended very frequently. So I think first off, thinking about amending house rules puts you ahead of a lot of other co-ops and condos. But doing that in a thoughtful, meaningful way, I think is a main differentiator, and seeking that out. That's part of the reason why I wanted to meet a lot of these board members as well, is that one of the theories that I've had and that I've seen, much like you, Lindsay, is that boards aren't necessarily being proactive in a lot of ways, and there isn't a proactive environment for boards to communicate with the property manager or legal counsel or CPA. And that's part of why I wanted to meet a lot of these board members, see if there would be interest in regularly scheduled office hours where you're able to answer questions about ongoing issues, certainly updating house rules and knowing what house rules are is really important in making sure that they follow the governing documents. So Shaheen, I'll encourage you to go to coopersmith.law/super and we can talk a little bit further about your house rules.
Great. And we've got some questions, I think, to build on that around specifically subletting and sublet policies and amending those. So first question about that is kind of, is that a house rule? How does that get amended? And then we have a follow-on question around just, what are board members allowed to do there? And, how drastic can those changes be?
Right. I think the first thing to look for is what's in the governing documents and overall in terms of what the board's authority is for the house rules, first and foremost. Going back to the presentation, a lot of it stems from the business judgment and why the board is deciding to increase the fees. There may be a reason for doing so, at least in terms of generating revenue for the co-op or condo, overhead expenses, other items like that. Or there may be punitive reasons for doing that, and why the board is segmenting out other individuals. So it's part first looking to the governing documents, and I'm gonna say that a lot. Second is understanding what the reasoning behind these increase in fees is, and whether or not the board is exercising the business judgment rule and its fiduciary duties in good faith, and why the board is doing so. If there are enough shareholders who protest that sort of behavior for increasing the fees, certainly the board could change its mind. But first, you want to make sure the authority, to understanding what the business judgment rule is, and then understanding that the courts generally hold a wide latitude for a board's exercise of business judgment.
And just to confirm on that, for a change like that, they would need to bring that to a vote of shareholders, or can they do that within the board?
That would be based off of what the governing documents
Based
say.
on the governing documents. So each condo or co-op should be looking at their bylaws to understand kind of the threshold for who can make what decisions.
Exactly.
But based on that, it sounds like the amount of the increase, even if it seems really high to some folks, can be justified based on the business corporation law.
Correct. Understanding the reasons why the board is increasing those fees, and the logic behind it, the board certainly has authority. Sublet fees, those sorts of items are generally in as part of the house rules, and that the board can make those decisions. But certainly, you would want to check the governing documents.
Great, thank you for that. We've got a follow-on question around the D&O insurance side. So notwithstanding D&O insurance, can directors and officers be held personally liable?
There are extreme cases where a director and officer can be held personally liable. I think if they're acting outside the conflict of interest laws, and that there is a distinguishable conflict of interest, you can be held liable for that. And I think there was also a case where a board member acted in an extreme way, and I think it was racially motivated in terms of a denial, and then the D&O insurance did not cover those certain intentional acts. So if you can't, just because you're a board of director and have D&O insurance doesn't mean you can walk around with a sledgehammer doing intentional acts or anything else. either an actual sledgehammer or a metaphorical sledgehammer, in terms of saying I'm on a board, I have authority as a board member, certainly have to act within well-reasoned judgment for the D&O insurance to kick in. And again, if you're doesn't necessarily have to be intentional, you could be grossly negligent, outside. Let's say you're a board member who doesn't attend board meetings and votes on something, without being aware of whatever else. That could be a case where you're not covered under your D&O insurance.
Really helpful. Question about providing some of these documents. So question around if it's possible that a co-op doesn't provide an offering plan for a purchaser's attorney for review. And we do hear this a lot around kind of, that sales and buying process, how to facilitate that and some of the friction around that. So I'm guessing that might be where this is coming from, but feel free for whoever asked that, to Frederick, to clarify that as well.
It's a very good question. I think, it's important to understand what the offering plan is in a co-op. Depending on the age of the co-op, the offering plan carries less and less significance. So if it's an older, the offering plan frequently talks about the specifications of the building and what building systems are in place, and the layout of the building. It becomes less and less relevant over time because a lot of those systems are being replaced, but it also can lay out or specify what the layout of each apartment is and other items. It's important to review for a purchase. If you're on a board and you want to facilitate easier transactions, you want to understand where that offering plan lies and get it in a central repository. It makes it a lot easier for a transfer to occur. And so it's a common frustration, but it kind of goes back to the point of, are you a board that's kind of struggling to tread water, constantly looking for these documents, or putting it into one sort of repository? And there may very well be a good reason for a seller to not have an offering plan. They didn't have an offering plan when they first purchased. It could be a small co-op or condo where it was converted by virtue of a no action letter, in which case you would probably want to see the no action letter and how the building was converted. But there are databases out there that have offering plans, and in the worst case, you could probably request one from the Attorney General, because they're all filed at one point.
Great. You mentioned e-bikes. What are the current trends in the regulation of them? We keep hearing about them exploding. So,
right. It's a very good question. E-bikes, certainly a lot of buildings have passed house rules because that's the quickest and easiest way to impose a regulation on it. If you're in a co-op, you certainly want to provide strength by virtue of amending your proprietary lease. And the reason for amending the proprietary lease, even though it's a higher threshold, is that you have a more colorable claim for terminating lease or imposing the consequences for a breach of the lease if you prohibit e-bikes in your building. So that could be an item to discuss in your annual shareholders meetings, garnering support for that. And a lot of times, this is actually an item where you can garner a lot of support for prohibiting e-bikes in a proprietary lease, simply because it is a health and safety issue, and you don't want a fire to occur in a building or any other item like that. And again, it's not necessarily these fires are also occurring across a broad spectrum of buildings.
okay, speaking of bans, there's a question around someone on my board wants to ban firearms. Have you heard of any board having success with this?
I have not off the top of my head. I think that um, you certainly run in the issue with firearms from a general standpoint is that you not exclusive to co-ops and condos, but nationwide is that you run into the issue of the Second Amendment, which is the U.S. Constitution and certainly supersedes um, uh, not just your co-op and condo governing documents, but state law, but city law and state law. And you run into U.S. constitutional issues, at least in terms of firearms. And if you have, a shareholder or a unit owner who, certainly wants to carry firearms, you know, you're going to run into that issue, at least in terms of a possible lawsuit.
I guess maybe a build on that would be, like you were talking about with obviously e-bikes is a very different example, but, having rules and regulations within the building around how they're stored and things like that. Could the building put some guardrails in place around the expectations of firearms within the building?
That's something I'd probably want to explore a little bit in a more nuanced way. Um, it's something I don't feel comfortable, at least at this point, talking about in terms of the Second Amendment rights. I personally support, the safety of the building, safety of the residents, and the safety of putting a firearm in a safe manner, but I don't know to what extent off the top of my head to where you run into issues with law for
That's fair. I think broader nationally, there's a whole sticky conversation around this as well. My final question will be around, I think, you recently spoke to Cooperator News on some of these things and around specifically the kind of just the turmoil we've seen with the local banks and the FDIC insurance of up to 250,000. I'm curious if there are, just how should board members be thinking about their responsibility to protect cash reserves?
It's a good question. I think it kind of goes back to good governance, communication, and understanding your responsibilities as a board member. So this is, at least in terms of bank security, this is not a time to hide or put your head in the sand in terms of where are your funds and what bank are they being held in and are they secure. I think certainly in terms of banks security, as a board member, you want to know where those funds are being stored, because at the end of the day, they're not your funds, they're the funds for the building. And shareholders and unit owners are entrusting you for good maintenance of those funds. So if they're in a smaller or regional bank, or a bank where it's just had their credit downgraded, that's something to be aware of. If you're in excess of the FDIC insurance, you may want to spread out those funds over a couple banks, but you want to be mindful of what those funds are being used for capital projects. So if you're thinking about, I want to spread our funds and put 250,000 in a CD, which won't be accessible for a year, understanding what's the likelihood of using those reserve funds within a year, and the safety of a bank. So, and it may warrant a case where you're speaking to a money manager or delegating that responsibility. Property managers certainly responsible for, managing the property. Part of that includes drawing from the bank account, transferring funds to make sure that all the bills are paid. But certainly spreading the funds across multiple bank accounts creates a heightened burden on the property manager. And that's something that you want to coordinate with your property manager, and whether or not that security is warranted. And certainly it's not something on a day-by-day basis that you want to monitor, but you have your regular board meetings. Is JP Morgan Chase, for example, or Bank of America still have the same strength of credit that they had the month before? and knowing exactly where the funds are stored and what's above the FDIC insurance limit certainly makes for effective board governance.
Great. We've just got a couple minutes left and a few questions. So I'm going to say rapid fire answers for these last ones. There's one about how does a condo owner go about helping to change policies? So there's a question around pet policy, right? Condo that doesn't allow pets, but they want to try to change that.
Not to sound too much like a broken record, but you want to look at the governing documents. So whether or not the prohibition on pets is based off of the bylaws or declaration, or if it's a house rule. And then house rule we talked about can be amended by the board. And then if it's in the bylaws, certainly has a higher threshold among the unit owners. One of the things for pets is if it's a medically necessary pet, then by law you're entitled to that exemption, and the board has to grant that exemption as well.
Great. And then final rapid fire, can the property manager president serve as the president of the board? So can your property manager be on your board as well?
I think that, it's a perfect example of what can be a conflict of interest in terms of a board member for also being the property manager. I think that's if the board wants to go down that path, documenting why this property manager is the most effective property manager, what are the competing bids, everything else like that, is important. But I think that at the end of the day, it's a very perilous path, and it opens up the board to a potential breach of fiduciary duty, certainly the president as well. And it would be our recommendation that either the individual who is the property management company, either the property management serve the building or that individual serve on the board, but not both.
Amazing. Thank you so much, Hal. For the folks that are still with us, I know we're just at time. We'll be sending a summary with a video, Hal's information, a recording of all of this afterwards. You're welcome to share that with your fellow board members. Thank you, Hal, so much for your time today. And thanks to all of our participants as well.
Thank you. There were some great questions as well. Appreciate everyone's attendance here today.
Yeah. All right. Have a great day, everyone. Thank you.